A will is a document that determines who inherits your property if you die. However, in order for the will to be effective, it has to be probated. And in a probate, a will gets submitted to a court and reviewed by the court to make sure that it meets the requirements of a will and that it's valid. And after it's accepted to probate, the probate court will appoint a personal representative who will then administer the estate for the deceased. And what that personal representative will do is carry out the terms of the will, which means distributing the property to the beneficiaries that are designated in the will to inherit property. Now, a will would only be used if a person dies and there is still assets that remained owned by the deceased. In that event, the will would be submitted to probate. A personal representative would be appointed, and then that personal representative would administer the estate. If the deceased dies owning nothing or has set up their affairs and their assets such that all those assets transfer automatically upon death to beneficiaries via beneficiary designation form or some other instrument, then the will becomes irrelevant and isn't used at all. A living trust provides a person with several benefits. The first benefit is that the person who creates the living trust, we call that a trust maker, if that person becomes incapacitated during their lifetime, then whoever is designated as a successor trustee in their living trust can use assets of the trust to pay for their bills and expenses. And it's a really efficient way to allow that to happen. It doesn't require getting a bank to honor a power of attorney. It's a smooth transition and it can provide a lot of care for the trust maker while the trust maker is still living. The second benefit in creating a living trust is that it allows the trust maker and the trust maker's family to avoid probate if the trust maker should die. And probate is a legal proceeding whereby a personal representative is appointed to administer the estate of the deceased. So that legal proceeding could be avoided if a person creates a living trust. And another component to that legal proceeding is it's all public. So the person's estate plan is made public. The benefit the living trust provides is you can keep that estate administration private because the trust is not a document that gets filed with any court or any public agency. It's a private document where you can keep how your estate is distributed and administered private and not open for public viewing. The other added benefit of creating a living trust is it allows the trust maker to better control what happens with their assets after death. So, with a living trust, you can provide that each one of your beneficiaries receives their inheritance in a separate trust. Now, the benefit each beneficiary receives is it provides that beneficiary with lifetime asset protection from any creditor. And this could be a divorce, it could be a lawsuit, a bankruptcy. As long as that beneficiary leaves their inheritance within their respective trust, then it's protected from all of those creditor claims. Now, there may also be other reasons to establish a trust for beneficiaries. You may have a beneficiary who's not wise and smart with spending money. So, if you left it to them in trust, then that beneficiary's inheritance can be protected from the beneficiary themselves and it won't be squandered on wasteless items. The second reason is you may have a beneficiary who has a substance abuse problem. If their inheritance is left in trust, then you can still use it to provide for the care of that beneficiary without having to worry that it's going to be wasted on drugs or alcohol. The other added component of leaving the beneficiary their inheritance in the trust is some people will question whether or not that beneficiary will have to deal with some kind of third party as trustee whenever they need money. Well, what you can do is allow the beneficiary to eventually assume the role of trustee over their respective inheritance. So this allows the beneficiary to have control over it with maintaining that asset protection, and at the same time not having to go through a bank or a trust company anytime they want to take a distribution from their trust. And then finally, the other reason to leave the beneficiary's inheritance in a separate trust is in the event you have an individual with special needs, and that special needs person is on government benefits. If the money were distributed to that beneficiary outright, it could potentially qualify or disqualify the beneficiary from receiving any benefits that they're currently on. By leaving it to that beneficiary in trust, you retain the ability for the beneficiary to access whatever government benefits they're on, and it gives them another resource of funds that they can use to provide for their care. So those are the primary reasons a, a living trust is preferred to a will or any other type of way to transfer assets at death. Well, the primary benefit between a will and a living trust is the asset protection that the living trust can provide your beneficiaries. That's a huge component, especially, in light of the fact that there's a lot of lawsuits that get filed in today's environment. Also, it allows you to protect that inheritance when you could have a bad spouse. You don't want the spouse getting your child's inheritance. So the lifetime asset protection that the trust provides really is a wonderful thing to the beneficiaries of the trust, and it helps to preserve that inheritance, which could potentially be used for subsequent generations if it's not all spent up by the first generation. Another really important thing about a living trust versus a will is it avoids probate. It keeps you out of probate, it keeps you out of court, which lowers the cost of administration for your family. And further, there could be will contests and fighting between different family members, and that all is part of the public proceeding. And a lot of the inheritance that a person has worked hard to build could be squandered in legal fees and court costs. So a living trust definitely helps mitigate some of those concerns and will contests and disputes. The other reason that a person would create a living trust is for the incapacity planning component. When the trust maker becomes incapacitated during the trust maker's lifetime, the trust is a very useful and efficient means of allowing a successor trustee to replace the trust maker and then use those assets to care for the trust maker's health expenses, living expenses, and so forth. So the living trust really provides a lot more benefits that a person wouldn't get versus a will. Now, when trying to determine uh, between do I create a will or do I create a trust, mostly it just comes down to the value or size of the estate. If the estate isn't very significant, then a person can get by creating a will and setting up beneficiary designation forms to allow people to inherit outside of probate. Direct transfer at death, and you don't have to worry about going through probate. The will then, in that scenario, serves only as a means of insurance if you forgot to fill out a beneficiary designation form or something. But generally speaking, if you have a substantial amount of wealth, and that could start anywhere from $300,000 to $400,000, and you want to leave it to your kids and try to preserve it and protect them from the bad events in life that could happen, then a living trust makes a lot more sense than a will. So whenever we create a living trust, we always create a will with that trust. And the reason for that is we want to make sure that if a trust isn't properly funded, and by funding, that means transferring ownership of assets from you into your trust. That's very important because the trust only works if assets get transferred either now or at death. If the assets aren't transferred and the trust isn't funded and you die, then a probate's going to be required because you still own those assets at death. So the purpose of creating the trust is transferring ownership so that when you die, all of your stuff is owned by your trust. If everything is owned by the trust, then a probate isn't required. But let's say, for example, you forgot to put a parcel of real estate into your trust. You died and you're still the only person listed on that title. Well, now that you're deceased, there's nobody living who can transfer that asset to your trust. So the will, which we call a pour-over will, which was prepared at the same time we prepared your trust, would be submitted to probate. And ultimately, that personal representative who's appointed would transfer that real estate directly to your trust, and then it gets distributed according to the terms of the trust agreement. Otherwise, if you didn't have that will and you only had your trust, then when that real estate parcel needs to be probated, it wouldn't transfer to your trust. It would transfer to your intestate heirs because you died without a will. So a pour-over will is a component of a comprehensive estate plan when a living trust is prepared, and it serves as a form of insurance to make sure that everything does get distributed under the terms of the trust agreement. If you're happy to determine whether a living trust or a will is appropriate for you, that's one of the things that we can discuss and review at our free initial consultation. Happy to do so. Feel free to give me a call to get scheduled today.